It's another beautiful day in Pasadena. I just want to share some thoughts. An interesting conversation I had with a potential client the other day. He was being sued and he insisted that it's completely meritless, no basis to the claim whatsoever. So even assuming he's correct, which I have no idea without analyzing the claim and seeing the lawsuit and doing a little bit of research and evidence gathering, but even if what he says is completely correct and that there is completely, meritless lawsuit, what does he do? So we touched upon this in my first vlog video, and it's just interesting. What he said to me was that he said, well, can't I just show up to court? I'll talk to the judge and I'll explain what happened, and he'll just let me out of the case because I have nothing to do with this. So I'll just explain it to the judge and he'll let me go. So I had to hold back a laugh, and I think I did laugh a little bit, but that's not how it works, unfortunately. There's procedures, and a judge can't just listen to one side of the story and then just let him go like that in 5 minutes. When sued, like we discussed in the last video, the quickest method of getting rid of a bad lawsuit is settling, usually. Besides for that, if you want to get rid of it, through law in motion, generally speaking, the earliest chance you have to attack and the other side and defend yourself in a lawsuit is by filing a demurrer and/or motion to strike. Now, these pleadings do not speak to evidence. They do not speak to factual allegations in the complaint. The only thing that these pleadings do, the demurrer and the motion to strike, is that they attack the sufficiency of the complaint. Meaning, when you file a demurrer, you're taking everything in the complaint as true, even though you claim it's completely garbage, but you take it as true. And your argument to the court is this: even if everything the plaintiff claims in his complaint is true, even if it's true, they have no lawsuit. One of the standard and perhaps famous ways of filing a demurrer is to claim that the statute of limitations has run, which means that in every lawsuit, at least in California, there's a clock that's ticking from the date of injury. Usually it's from the date of injury, or it might be from the date you became aware of the injury. There's a lot of details to this, obviously. It's not a one-pager, but if you get sued, and it happened a long, long time ago, you might file a demurrer. And the basic gist of the demurrer would be, even if what they say is true, it's too late. Because this happened 10 years ago, and the statute of limitations for this sort of claim is 2 years, or 3 years, or 4 years, or whatever it is. Now, the truth is, outside of that sort of demurrer, and even those demurrers, they're not open and shut. There's a lot of different things, like I mentioned. If the plaintiff didn't know about the injury until much later, the clock, might not have started ticking until he found out about it. So even if it did happen a long time ago, if he only became aware of it recently, sometimes that allows him to file a lawsuit. But besides for that, most demurrers, don't really work. They're really part of the negotiation process. And sometimes maybe you file a demurrer just to show the other side, hey, we're here. We're not running away. We're not giving in real easy. This is going to be a tough case for you. And you're taking this, and to the other attorney, you're saying you're taking this on contingency. So if you think you're just going to get a quick buck, that ain't this case. It's in your best interest to sit down, be reasonable, and let's have a talk. Because other than that, we're going to fight this tooth and nail. A lot of different strategies, a lot of different ways of thinking about it, but unfortunately, even if you're 100% right, you can't just go to court and explain your case to the judge and expect to get out of it. Have a great day.